Thanks to Indochino for keeping Legaleagle in the air and helping me look fly. Donald J. Trump is the third president in history to be impeached. That means we are on to the final stage, an impeachment trial before the Senate. So what's going to happen, and what are the rules, if any? Hey Legal Eagles, it's time to think like a lawyer, because the president is going to trial, and he's going to need some good lawyers. While the Constitution contemplates a trial, this is very much unlike the kind of trial you would normally see at your local municipal courthouse. First, the rules at play in this trial are very much unknown. There are no specific rules of procedures for matters such as how evidence is presented, the scope of the hearing, and the witnesses. Unlike a criminal trial at the state or federal level, where the rules of evidence and the courtroom procedures are set usually by statute, here specific decisions on these matters will be handled by a simple majority vote by the Senate. Second of all, Chief Justice John Roberts will be playing the role of the presiding officer of this quote-unquote trial. Think a judge, but with more ambiguous authority. Still, his role at this trial adds some interesting wrinkles that we'll talk about in just a second, both based on his judicial disposition and past interactions with the president. And additionally, all of this is happening with the president running for re-election in less than 1 year. Given the whole fluidity of the situation and the fact that the senators are going to have to act not only as the jurors, but the lawyers, the judges, and the people that set the rules for the judges, this whole situation reminds me of the improv game show, Whose Line Is It Anyway? You know, the show where everything is made up and the points don't matter, where Drew Carey just picks whoever he wants at the end. And I guess in this metaphor, Drew Carey is Lindsey Graham. On tonight's show are the Democrat House managers, the Senate, and presiding officer Chief Justice John Roberts. And I'm your host, Devin Stone. So Legal Eagles, come on down, let's have some fun and make some stuff up. Well, at least we'll try to avoid making anything up. But let's talk about the upcoming Senate impeachment trial, where little is known and almost anything is possible. But first, the question of whether there will actually be a trial in the Senate. Recently, we've learned that Speaker of the House Nancy Pelosi has intimated that she intends to delay sending the articles of impeachment from the House to the Senate in order to provide leverage and force the Senate to have a fair trial against the president. Does Nancy Pelosi have any legal basis for that? Well, we're in sort of constitutional gray areas here. The Constitution says that the House has the sole power of impeachment and that the impeachment shall be tried in the Senate. But beyond that, it's all sort of up in the air and ambiguous. Certainly past precedent indicates that this is not how it has happened in the past. With the impeachment of President Clinton, there was not much of a delay between passing the articles of impeachment in the House and actually going forward with the Senate in the trial. With Nixon, he resigned before the Senate trial, so this situation simply never came up.
In all the decisions I have made in my public life, I have always tried to do what was best for the nation.
But because of the constitutional ambiguities, there's room for both sides to argue that this is allowable and that it's completely improper. Additionally, on a practical level, it's unclear what effect, if any, this will have on the eventual Senate trial. First of all, Congress is just about to break for the winter holiday. On top of that, it takes time for the House to appoint the managers who effectively act as the prosecutors and defendants' attorneys in the Senate trial. And on top of that, the Senate still has to agree on what rules will govern the Senate trial itself. So it's not like Congress is in a position to move forward with the impeachment trial anyway. But people have analogized a presidential impeachment to an indictment in a criminal case. The indictment itself doesn't actually do anything. So the fact that the House has impeached the president doesn't mean anything until there is formal action in the Senate. In the same way that you can get an indictment against a criminal defendant, and that won't have any effect on their life until you actually move forward with a trial that will either convict them or acquit them of the crime that they are accused of. So it's not necessarily in anyone's interest to simply have an indictment or an impeachment sitting out there in the ether with having no effect on the president. Of course, it's not a good look to engage in constitutionally dubious behavior when you're accusing the other side of violating the Constitution. So given that President Trump has been impeached, but that it has very little effect on the presidency itself, and without constitutional guidance here, I would expect that this might be a delay of a few weeks, but eventually the Senate trial will go forward because otherwise the impeachment has no real effect. So first, let's talk about the constitutional language that actually governs the impeachment proceedings to date. We can start with Article 1, Section 2, Clause 5, which states that the House of Representatives shall choose their Speaker and other officers and shall have the sole power of impeachment. In this case, the House exercised their sole impeachment power on December 18th by formally impeaching President Donald Trump on 2 articles of impeachment. So where does the Senate come in? Well, for that we have to look at Article 1, Section 3, Clause 6, which states that the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without concurrence of 2/3 of the members present. So, as to what procedures the Senate has to follow, the Constitution is largely silent. We know that the senators will have to take an oath or affirmation, that the Chief Justice will preside over the trial, and that conviction and removal of the president requires a 2/3 majority of the senators present at the time. So the vast majority of procedural rules that are going to apply in this particular trial are going to have to be decided by the current sitting Senate, largely determined as a negotiation between Senate Majority Leader Mitch McConnell and Senate Minority Leader Chuck Schumer. They'll be decided as an ad hoc basis for this particular proceeding. There are, however, some helpful guidelines put out by Congress in the publication called Rules of Procedure and Practice in the Senate when sitting on impeachment trials. So let's try and flesh out some of the Senate rules and guidelines that are likely to shed light on what the trial is going to look like in this particular case. First, and ultimately of greatest overall importance, a vote of 2/3 or what's referred to as a supermajority of the Senate is required for conviction. This is required by the Constitution, and no amount of Senate rules are going to be able to change that. Specifically, the Senate impeachment rules state that if the impeachment shall not, upon any of the articles presented, be sustained by a vote of 2/3 of the members present, a judgment of acquittal shall be entered. This can be distinguished from the simple majority needed to actually impeach the sitting president. Now, of course, there is a big difference between general impeachment of a president and removal of office. Impeachment occurs when the House says it occurs, and that's done by a simple majority vote, whereas conviction and removal from office happens only in the Senate and is conducted by the senators, not surprisingly. But what about the trial itself? By way of background, many frame the whole impeachment process akin to a criminal proceeding. The House of Representatives has the, quote, sole power of impeachment, which can be compared to the indictment process in a criminal proceeding. Basically, this means that the House is charged with making a formal charge against the president. However, it's the Senate which has the sole power to, quote, try all impeachments, acts as both the jury and the judge by hearing the evidence, determining whether to convict the president under the articles of impeachment, and if convicted, to determine the appropriate sentence as a result of that conviction. Now, many of you legal eagles are probably thinking right now, but wait, if the Senate is in charge of the trial of the president, and we know that the vice president is tasked with presiding over the Senate, isn't there a conflict of interest? Well, yes, but fear not, because Article 4 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials states that when the President of the United States or the Vice President of the United States, upon whom the powers and duties of the office of President shall have devolved, shall be impeached, the Chief Justice of the United States shall preside over the Senate during the consideration of said articles and upon the trial of the person impeached therein. So that means Chief Justice Roberts, not Vice President Pence, will be the presiding officer for this particular trial. For the impeachment trial, the presiding officer is given the, quote, power to make and issue orders, mandates, writs, and precepts authorized by these rules, and rule on all questions of evidence, including but not limited to questions of relevancy, materiality, and redundancy of evidence and incidental questions. This would seem to indicate that the Chief Justice will have all of the power afforded to a judge in a standard hearing, but there's a big but here. The presiding officer's ruling shall be accepted as the judgment of the Senate, quote, unless some member of the Senate shall ask that a formal vote be taken thereon, in which case it shall be submitted to the Senate for decision without debate. So basically, the presiding officer has the power to make these decisions, but if the senators do not like the ruling, they can override it with a simple majority vote. In fact, majority votes in the Senate can be used to decide almost all key questions that in any normal trial proceeding would be decided by the judges under the law. The Senate itself wields a great deal of power in control of this trial. In addition to being able to take any decision by the Chief Justice to a Senate vote, it has the broad, sweeping responsibility of directing all necessary preparations for the consideration of impeachment articles. They can also, quote, compel the attendance of witnesses, enforce obedience to its orders, mandates, writs, precepts, and judgments, punish in a summary way contempts of and disobedience to its authority, and here's the big one, make all lawful orders, rules, and regulations which it may deem essential or conducive to the ends of justice. For all intents and purposes, the Senate is the judge, jury, and executioner. With 53 Republicans in the Senate, for the Democrats to have any say in how this trial will be conducted, absent unlikely bipartisan agreement, it would require more than 3 GOP defections on any impeachment-related motion, which are decided by simple majority votes. So let's talk about past precedent from the past presidential impeachment hearings. It's been 21 years, almost to the month, since the last presidential impeachment hearing, and this trial will only be the third in the nation's history. So let's look to the rules that govern the Clinton Senate impeachment trial to see if we can glean any rules that will likely occur in this particular case. In looking at the impeachment trial of President Clinton, there are 2 particular observations that will be helpful in assessing how a Senate impeachment trial might look today. First, a look at how the rules for the trial were decided by a then divided Senate, similar to what we are dealing with today. And secondly, the role of the presiding officer, then Chief Justice William Rehnquist. First, looking at how the rules were decided upon. Despite a very divided Senate at the time, all 100 senators voted to approve bipartisan procedures for the Clinton impeachment trial. At the time, Senate Majority Leader Trent Lott famously worked with Senate Minority Leader Tom Daschle to come up with a set of rules for the impeachment.
Senator Daschle and I are not dictators. We are leaders that are giving some latitude by our conferences and our caucuses, but we have to bring along 98 other senators.
The bipartisan agreement settled on procedures such as allowing 24 hours for each side to present their case, followed by 16 hours for senators to ask questions. There was less agreement, however, when it came to the subject of witnesses. A resolution dealing with witnesses passed on a strictly party line vote. Ultimately, the democratically controlled Senate chose to only allow 3 witnesses per side, and they were all deposed privately in the presence of a senator from each party, not actually in the Senate floor during the course of the trial. Now, parts of their depositions were shown by video during the trial, but despite Republican best efforts, no live testimony or cross-examination was allowed. Now, as far as Chief Justice Rehnquist's impact on the Clinton impeachment hearings, based on most accounts, his most notable contribution with the trial was a custom-made robe with 4 gold stripes on each sleeve. Rehnquist was largely considered to have taken a hands-off approach during his role as the presiding officer in the Clinton impeachment trial, deferring to the Senate on almost all matters. In fact, Rehnquist himself is quoted as saying, "I did nothing in particular, and I did it very well." When he did make a ruling, the conservative Chief Justice was considered by even Democrats to have an even-handed approach. For example, in one instance, Rehnquist upheld an objection from a Democratic senator regarding the House managers referring to the Senate as, quote, jurors. Rehnquist stated, "The Senate is not simply a jury, it is a court in this case." For the most part, however, Rehnquist left questions related to witnesses and motions for the senators to negotiate. He kept both sides moving on schedule and mainly handled procedural objections. The Democrats restricted the Republicans from being able to conduct the trial as extensive as they initially wanted, and Rehnquist didn't do anything to interfere with that decision. At the end of the trial, President Clinton was acquitted on both articles of impeachment brought before the democratically controlled Senate: perjury before the grand jury and obstruction of justice.
2/3 of the senators present not having pronounced him guilty.
So, using the Clinton impeachment trial as a template, let's talk about the current state of affairs with the impeachment trial of Donald J. Trump. Now, how the Trump impeachment trial is going to play out procedurally, the amount of witnesses, and the amount of evidence ultimately allowed is anyone's guess. So is whether and which side would want to attempt to lengthen or shorten this trial. To give you some frame of reference, the Clinton Senate impeachment trial lasted for 5 weeks. There are plenty of conflicting reports about Republicans wanting to shorten the impeachment trial or also wanting to lengthen the impeachment trial to be able to call witnesses like Hunter Biden or Nancy Pelosi. Sometimes we hear that the president wants a very lengthy trial to be able to prove his innocence, and sometimes we hear that he just wants to get it over with. Now, from the president's thumbs himself on Twitter, he states that if you're going to impeach me, do it now, fast, so we can have a fair trial in the Senate, and so that we can get our country back to business. We will have Schiff, the Bidens, Pelosi, and many more testify, and will reveal for the first time how corrupt our system really is. I was elected to clean the swamp, and that's what I am doing. Similarly, there have been conflicting accounts of what the Democratic strategy is going to be as well. Some say that they simply want the Senate trial to be conducted as quickly as possible to have a strict vote on the articles themselves, and some want to be able to call the first-hand witnesses that the Trump administration has blocked from participating in the impeachment hearings before the House. But both the Republicans and the Democrats contain multitudes, so there may not be an overarching strategy for either side. But given the fact that the rules, or lack thereof, allow the Senate to create almost any rules that they want, nothing is off the table. The Republican-controlled Senate could potentially, depending on the rules set, propose and pass a motion to dismiss the charges before a formal hearing is even conducted. In addition, they could have a trial and either limit or aggressively expand the amount of evidence and witnesses that are to be examined. They're not bound by a predetermined set of rules that address matters such as relevant evidence or hearsay as set forth in the federal rules of evidence. The Senate could adopt the federal rules of evidence if they desired, but the Constitution doesn't mandate that they do. The status of witnesses is also up in the air. It's all reading tea leaves at the moment. It appears that the president wants to call witnesses and that other Republicans may not want that. But the thing about impeachment rules, at least historically, is that they tend to be symmetrical because it could always be your party that's on the hot seat. And so history does provide a constraint. Generally speaking, whatever is allowed for one party is generally allowed for the other party as well. Now, that isn't necessarily how it has to go down. The Senate can make whatever rules it wants, but because you never know who the next president is to be impeached, you probably want to set a precedent of reciprocity. Now, interestingly, polling appears to show that the vast majority of Americans are in favor of hearing from the members of President Trump's staff that have firsthand knowledge of the whole Ukrainian affair, including acting Chief of Staff and head of OMB Mick Mulvaney, Secretary of State Mike Pompeo, and former National Security Advisor John Bolton. But at the moment, it's incredibly unclear as to whether Senate Republicans feel similarly. In terms of strategic considerations, there are all kinds of theories swirling about Republican and Democratic motivations about the Senate trial. For instance, some believe that the Democrats are possibly using the Senate impeachment trial as a way to fast-track obtaining witness testimony from key witnesses that were subpoenaed in the House and refused to testify or provide documents. The theory stems from the fact that the House of Representatives did not go to court to compel the testimony of no-show witnesses, such as National Security Advisor John Bolton or Secretary of State Mike Pompeo. Essentially, the argument is instead of waiting for appeals to go all the way to the Supreme Court, where Chief Justice Roberts would vote on these particular matters anyway, they could take a shortcut and let him make the decision as the presiding officer during the Senate impeachment trial. It's certainly interesting, but there are a couple problems with this theory. First, the Senate rules already state explicitly that they have the power to compel witnesses. The Democrats most likely won't have the votes on a motion to have these witnesses testify. And second, even if there is a scenario in which Roberts makes a decision regarding the testimony of those witnesses, that decision could be overruled by a majority vote of the Republican-controlled Senate. Hanging your hat on Republican senators' unwillingness to vote against a conservative judge for political reasons seems unlikely. As far as what we can expect from Chief Justice Roberts in his role as the presiding officer of the Senate trial, it's worth noting a couple of things. Number one, he is the former law clerk of Chief Justice Rehnquist, and he identifies as an institutionalist who prides himself as being protective of the reputation of the court. For example, Chief Justice Roberts once rebuked President Trump after criticizing a court ruling made by a, quote, Obama judge. Roberts said, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before him." Indeed, some of the most recent Supreme Court cases where Justice Roberts has voted with the majority have shown extreme deference to Congress. In one particular case, the Supreme Court allowed a representative body to even gerrymander their own geographical districts. So in terms of what you can expect from Justice Roberts in the Senate impeachment trial, probably you can expect him to play it extremely safe, to not rock the boat, and show extreme deference to the senators and whatever they decide. So how this trial will look will largely be based on either the hands-on or hands-off approach of Chief Justice Roberts, and ultimately how the Republican-controlled Senate votes to set the rules for the trial itself. The bottom line is that most major decisions are ultimately at the discretion of the Senate itself. Basically, there are relatively few rules that can stand in the way of a Senate majority, and most of them are fairly easily changed. What is certain, however, is that if you're going to be a defendant in trial, even if you're the President of the United States, you need a great-looking suit. The last thing you want to do is show up in court with a tie that is 10 inches too long, wearing a jacket that is 2 sizes too big, wearing pants that are even too big for MC Hammer. So, Mr. President, if you're looking for a custom slim-cut suit that is shockingly affordable, I can't recommend Indochino highly enough. All of my suits are now made by Indochino, including this blue 2-button that I'm wearing right now, which was custom-made just for me. Because the secret of a great suit is all about the fit. I'm a reasonably athletic guy, and I can never buy suits off the rack because they just simply never fit right. If the shoulders fit, the waist is too small, and either it doesn't fit or it costs a ton to have a tailor fix it. But with Indochino, you can send in your measurements online, or you can go to one of their stores and have a stylist take your own personal measurements. My first time, I made an appointment. I went to the store in person, had a stylist work with me for over 90 minutes when I went in for the first time. My personal stylist took my measurements, and a couple weeks later, I got the best fitting suit of my entire life. It was perfect right out of the box. And if it wasn't, Indochino would have tailored it for free. Indochino will make you a fully custom suit tailored specifically for you for less than $400. And the best part is, they still use the best materials like Super 140's wool. And Legal Eagles can click the link in the description to buy any premium Indochino suit for only $359. That is an insane deal. You can also use the promo code LegalEagle, and if you go in person, tell them Legal Eagle sent you. I will never buy an off-the-rack suit again, and once you try Indochino, neither will you. Legal Eagles can get any premium Indochino suit for just $359 when you click on the link below or use the promo code LegalEagle at checkout. Clicking on the link in the description really helps out this channel. So check out Indochino.com, use the promo code LegalEagle for the best custom suit of your entire life. So, do you agree with my analysis? Leave your objections in the comments, and check out this playlist for all of my other real law reviews over here, where I will see you in court.